Please be seated. Good morning again. The third and final case for oral argument this morning is Jody FRYE-BYINGTON appellant versus Rapid City Medical Center and others appellees. For the appellant, we have Mr. Arshawn Turno, an attorney from Sioux Falls, and for the appellees, we have Mr. Lonnie Braun, an attorney from Rapid City. Justice Kern has disqualified herself on this case, which gives us the opportunity to welcome back an old friend, former Justice of this court, Justice Judith Meyer Henry. Always great to see you again. And with that, Mr. Turno, you have 20 minutes, sir.
Thank you, and may it please the court, counsel. I'm here today on behalf of my client, Jody FRYE-BYINGTON from Rapid City, as she appeals the result of her jury trial out in Pennington County based on her claims of medical malpractice against the Rapid City Medical Center and Rapid City doctors serving with and under as employees and agents for Rapid City Medical Center, Dr. Burgess, Dr. Rafferty, and Dr. Welch. Initially, I want to point out to the court that I believe, as we dealt with throughout trial and even as a part of this appeal, that appellees, Rapid City Medical Center, misconstrues and or miscontorts the essential claim of medical malpractice here. That is, and I'm sure you'll hear counsel address, that when we talk about Jody FRYE-BYINGTON's expert in this case, that, gee, she wasn't an ENT, an otolaryngologist. And therefore, at the crux and the heart of this case is Dr. Burgess and his ongoing and continuing care or what should have been care and treatment and information provided to Jody FRYE-BYINGTON over the course of 2008 to 2014. Or Dr. Burgess and his office sent my client to urgent care. And I think what appellees in misconstruing what was presented or the theory of the case, they say, at what point can you say with an expert witness when surgery should have been performed to, as this court knows, deal with the large mass that grew in, unfortunately, in Jody FRYE-BYINGTON's chest over the course of these 6 years. In fact, it's the size of a hockey puck, 7 centimeters by 4.8 by 3.7, a very large mass. And as this court knows from the briefing and through the trial, Jody FRYE-BYINGTON, unfortunately, was never informed of that, either by Dr. Burgess, Rapid City Medical Center, or any of the agents, employees therein. And the crux of the malpractice...
I'm sorry, but you're on Dr. Burgess, and I was going to talk with you about the claims against Dr. Burgess. One question that I kind of have a follow-up. What effect, if any, does Dr. Burgess' alleged negligence have upon the allegations involving Dr. Rafferty and Dr. Welch? Or are they freestanding allegations that will either, win or not win, or prevail on appeal or not prevail on appeal on their own merit? Is there a derivative component of your allegations of negligence against Dr. Rafferty and Dr. Welch that depends in some way upon Dr. Burgess's alleged negligence?
Thank you for the question, Justice Salter. And we would say on behalf of Jody FRYE-BYINGTON that Dr. Burgess is the linchpin of the beginning of the negligence that took place here through the failure to inform and to try to, as our expert said, Dr. Wright, as a physician, they have a duty to inform and a duty to gain informed consent of Jody FRYE-BYINGTON about what was going on within, as to the mass in her chest as it grew over the 6 years. To answer your question directly, all these claims are under the umbrella of Rapid City Medical Center. Appellees don't want to address that. They say, well, no, the claim here is against these three doctors. No, the claim here, as originated by Lance Russell, her then attorney, was against Rapid City Medical Center and the then known doctors and healthcare providers that most directly dealt with her.
But the theory of their liability, if correct me if I'm wrong, the theory of liability as to Rapid City Medical Center is one of vicarious liability. There's not, in other words, as I understand it, a direct claim. They failed to train or supervise, or they were negligent in hiring or retaining these doctors. Their liability, it seems, would derive from whatever negligence can be proven as to these three doctors. Am I right on that?
And we would submit that under the, and we'll probably get into the Clark versus Southview Hospital case out of Ohio that supports the jury instruction that we'll talk about, that really it is a claim against Rapid City Medical Center and their employees and agents. And then at the time, and what this needs to take into account, Justice Salter, is today's delivery of health care is different than yesterday's, obviously. And here, we think the unique aspect is the urgent care referrals. As the court knows from the facts of this case, the protracted maladies that my client suffered with over the years, she just kept going to or getting referred to urgent care, urgent care, urgent care. That's Rapid City Medical Center. To the extent that she was treated by and under the auspices of Rapid City Medical Center through their urgent care program, we would say there is a claim there. And it's to this extent. She goes to urgent care, as any of us do. We don't say, I'm here to see Dr. Burgess. Obviously, that wouldn't apply. He's an ENT. But she doesn't go and say, well, I want to see today my doctor, Dr. Welsh. No, it just happens that Dr. Welsh is on call through urgent care. Another time, Dr. Rafferty is on call. That's why they're named. Dr. Gillen is another employee and agent of Rapid City Medical Center who, again, the trial court ultimately allowed us to get into the negligence in the additional failure to inform Jody of this growing mass, time after time after time.
Let me ask it this way, if I can. What independent duty, separate and apart from the standard of care that was owed by the physicians, what independent duty, if there was one, did Rapid City Medical Center owe to your client?
The independent duty of, through their urgent care offerings of medical care, whether that's Welsh or Rafferty or Gillen or Brandt or Graham, others, to the standard of care that Dr. Wright testified to, was that there was a duty to inform.
And those are duties that the physician owed, and I understand your argument in that regard. Those are duties that the physicians would owe to any patient. And if there's negligence and a breach of that standard of care, then there's your negligence. And the agency theory then seems to be that's how you would establish liability for Rapid City Regional. Is that right?
I would agree with that.
When was the last time Dr. Burgess treated your client?
I believe, well, he can...
And I understand you may have to break that up a little bit. Go.
Right. It went back, of course, I believe in 2005, he completed a surgical procedure. And then what happened here to begin this process is at 2008 that he was aware of a growing mass. And he decided independently, without consulting Jody FRYE-BYINGTON, nothing to see here. I'm not going to inform her about it.
So when did he last see her for that issue right there? Was it in 2009?
I think then there was a follow-up in 2009. However, what we established at trial is Jody considered, and it's backed up by documents in the record, Jody considered Dr. Burgess, even though he is an ENT, as her family doctor, her friend, whatever. And to that extent, the treatment and his care continued insofar as he continued to do tests or authorized tests and authorized prescription and re-prescriptions, and therefore would indicate that he's continuing in her care.
So we've got a rule for that.
I'm sorry.
In Pitt Hart, we've got a rule that says, because now I'm talking about the statute of repose issue. And our rule says, as you know, that if there's a continuous and unbroken negligent treatment, and that the treatment is so related to the continuing wrong, and both of those components are there, we can apply a continuing tort doctrine. Though it's not tolling, we can deem the statute of repose not commenced until the end of all that. So within the framework of that test, I hear you saying that there was continuous treatment after the 2009, maybe in the form of prescribing the Synthroid and doing that sort of continuing involvement in the case. But what about that second prong? That treatment, that lingering treatment after 2009 is so related as to constitute a continuing wrong and connected to the 2008 or 9 negligence that you've alleged.
Thank you for the question, Justice Salter. And we would say this again is where appellees have really misinterpreted this. They want to rely on Pitt Hart to say, oh, statute of limitations before Jody's attorney, Mr. Russell, could file the case, the statute of limitations ran. However, you're correct in asserting that on behalf of the appellant, we submit, and the trial court agreed, that this is a continuing tort, which my term would be, maybe it's right or wrong, I haven't even looked it up, but it forestalls that running of the statute of limitations. That happened here, and that happened beginning, the continuation of treatment, again, starting with the linchpin of Dr. Burgess, 2008 through 2010, through 2009, 2010, 2011, and we have documents, we can talk about those for what we sought to get in as rebuttal, as he claimed, gee, he didn't know. Am
I right in thinking that 2009, can we maybe just isolate on that for a second? Am I right or wrong in thinking that 2009 was the last point at which Dr. Burgess saw your client and would have, maybe in your view, had the opportunity to disclose the medial sternal mass?
We would respectfully disagree with that because he continued to reorder these tests for the thyroid and the prescriptions that go along with that.
How were they related? How are they related to, which is the test in Pitt Hart? How are they related or connected to the failure to advise your client of the mass?
Very good question. We would submit they tie in because during that same time frame after 2009 through 2011 into 2014, he continues to order. He continues to be treating her as the ordering physician, the treating physician to order these things, and it's continuous in that it's all related to the thyroid, and at the same time, in the Rapid City Medical Center records, there are CT scans and ultrasounds showing that the mass is growing. Commenting specifically, consultation with Dr. Burgess should be done here. Someone needs to, it's in the record, someone needs to advise the patient of this. But nobody did.
Is he seeing her, though? Is he seeing her for that problem along the way? And I'm terribly sorry for this compound question, but am I also right in thinking on the medical evidence, your client was going to need Synthroid probably for the rest of her life anyway by virtue of something that's unrelated to the failure to disclose?
I would agree with the last part of that. What I would answer the first part of that, Justice Salter, is that during that time, however, Rapid City Medical Center and the other providers are seeing her, and again, she can't select who's seeing her directly, and we have testimony that says Dr. Burgess' office sent her to urgent care. Now, they tried to present a witness that discounted that to some extent, but testimony was that she kept getting referred there by Dr. Burgess. And even in today's world, whether he technically met the terms of a primary care physician, if the physician's office is sending you to urgent care, we would say that's, again, part of the linchpin of he is a part of the continuous care, the omissions thereof in failing to inform her of this large growing mass that caused her such problems in her life. And therefore, we think that we do meet the criteria, as the trial court held, that the continued tort doctrine applies, and therefore, again, forestalls what they want to claim as a statute of limitations. This kind of ties into that in appellee's own instruction. they inform and tell the jury that these doctors are agents, but by inference, they're saying they're the only agents. Well, we know, however, that Dr. Gillen was a part of that, again, under the auspices or the umbrella of Rapid City Medical Center, and ordered a test stat immediately to find out what's going on with this constant coughing and wheezing and hoarseness, and for Jody to come see urgent care some 60 times in the course of 6 years. That's not normal. And that, Justice Salter, we would say is part of the continuous care and treatment, none of which, again, during those 60 visits or as related thereto, does anyone inform Jody FRYE-BYINGTON that, by the way, you have a hockey puck mass that they didn't know was malignant or benign. Thank goodness it was benign, but it's growing in your chest and it's pushing on your trachea. It can be part of the cause of the symptoms that you keep showing up for, that we, Rapid City Medical Center, and whoever she might see in one of the 60 times that she goes to urgent care, that leads to the health problems that you're having. Instead, they send her off with a Z-Pack and say, well, hopefully she doesn't come back. Well, ultimately, as the court knows, in 2014, after just weeks before, when Dr. Welsh told her in urgent care, notes in his record, you're hysterical, Jody's hysterical, and her concerns that she has are just BS. We know what that stands for, are just BS. Not about 2 weeks later, she goes to Mayo Clinic, and of course they see the mass. The thoracic surgeon specifically notes this needs to be taken out because it can be the cause of continuing cause of her problems. We think that also supports this that the treatment or the ungiven treatment or the neglected treatment or failure to inform her was so related as to constitute one continuing wrong. Another one of the leg stools, if you will, of showing that this was in fact a continuous tort.
Mr. Torno, I have a question now. Now, you didn't sue some of these doctors are unnamed in your lawsuit, right?
Correct.
It almost sounds as if your theory then is that the medical, the overall umbrella, the regional medical center, has a systemic problem of not having communication among their doctors or something, but you did not sue it out. It's the individual doctors that you sued.
Well, again,
Yeah,
Lance
you're
Russell.
talking about doctors that were not actually part of the lawsuit.
Right. Lance Russell, when he sued it out, did sue Rapid City Medical Center and these three doctors. Again, we would say appellees try to limit that. That otherwise you cannot address any other providers that came up as a part of the negligent or the uninformed care provided through the duration. And we would submit that those can come in. Again, when you look at the Clarkview Southview Hospital case, we do think that's an important case and really does support the standard agency instruction that South Dakota has long held. And in Clark versus Southview Hospital, of course, in 1994, the Southview court said that the public has every right to assume and expect that the medical facility is the medical provider it purports to be, and that the medical facility may be held liable under the doctrine of agency by estoppel for the negligence of independent practitioners.
2 minutes.
Thank you, Judge. We would just further assert that we think it's important in showing this ongoing failure to care, that it was critical that we be allowed to get into Exhibits V and V1 that were disallowed by the trial court. And that is, we should be allowed in refuting Dr. Burgess's testimony. He didn't know any of this. And after he would support what Justice Salter said, after 2009, I'm out of this, even though I continued to provide services by referring her on in prescriptions. These two exhibits, of course, in 2010, 2011, show specifically that mass is growing and that Dr. Burgess was copied with that information and that consultation needed to be made. for the first time at trial, Dr. Burgess says specifically as to Exhibit V, never seen it, even though it shows I'm copied, never had it, don't know anything about it. We should be allowed, especially under the Sorensen case, that says we be allowed to rebut that testimony, and it should not be excluded if to exclude it would hinder the truth-seeking process at trial. That's what we thought here.
I thought that he had testified in his deposition that he'd never seen that, and that V or V1 or perhaps both of them were draft reports, and that the Rapid City medical records or the medical records from his care didn't indicate that he was copied. But in any event, I thought that his deposition testimony was clear that he had never been copied or seen those reports, those radiological reports in V and V1.
He testified he hadn't seen V1. We didn't address V. And V1 and V2 are really are two peas in a pod, if you will, and doubly showing that he was copied and that he should have known and he should have informed and failed to do so. And we think also, as to issue 2, that an agency instruction was appropriate under Clarkview Southview Hospital, and as it's shown in Appendix F, that the changes made so affected the whole of the instructions given that it can be reviewed de novo here, and that they're faulty. One quick error that if I can point out.
Your time has expired, counsel. Thank you.
Thank you.
Mr. Braun, you have 20 minutes, sir.
Thank you, Your Honor.
May it please the court, counsel, ladies and gentlemen of the gallery. It's been 39 years since the first time I addressed this court. It says a little something when I look around and there's not a single justice on the court that was there for the finals of the moot court competition in 1981. I do want to thank the court for giving me an opportunity to proceed with the defense of my clients, Rapid City Medical Center, Doctors Burgess, Rafferty, and Welsh, in supporting the unanimous jury verdict that was given to them after a 6-day trial, and them hearing all of the evidence and the materials. I want to start with some of the questions that were asked. Justice Salter asked about the statute of repose, and the standard is precisely what he said it was. There were some questions that he asked. Number one, when did Dr. Burgess last treat Ms. Byington for this condition where it may have exposed something about this aberrant thyroid tissue that was growing in her chest? The last time he saw her in clinic was on October 27, 2009. This case was served on Dr. Burgess on July 22, 2016. That's a bit past the statute of repose of 2 years. Last week, this court affirmed the holdings of the Pithart case. It is good law, and they reaffirmed the fact that a continuous treatment thing will not stall the running of the statute of repose, that once the time is gone, it's gone. So the fact of the matter is, Mr. Counsel has indicated that the linchpin of his case is Dr. Burgess in 2008.
Well, let me ask you this, Mr. Braun. After 2009 or whenever it was that Dr. Burgess last saw the plaintiff, what specifications of negligence or opinions of breaches of duties were testified to by plaintiff's experts after that time, either by Dr. Burgess or anyone else?
Yes. Plaintiff's expert, and one of our notice of review issues is undisclosed opinions. At her deposition, she said nothing about Ms. Byington calling in and getting her thyroid medicine renewed. At trial, she then went into this thing of, well, they should have done this test. But the fact of the matter is, Justice, that the renewal of those TSHs had nothing to do with the issue of, is there a mass that's maybe causing some kind of a harm to this lady?
So there was no testimony or expert testimony or opinions addressing the fact that this medication or anything associated with it was a breach of professional duty of care.
Dr. Wright, a family doctor from Minnesota, testified that in her opinion at trial, again undisclosed before trial and overruled by the trial judge, but at trial testified that, she sees that the TSHs were renewed over periods of time when Ms. Byington would call in. And yes, I can't remember who made the point of she's going to need this thyroid medication for the rest of her life. She had no thyroid. She did need the medication. There's no question about that. But we go back to their issue is this hockey puck, as they want to call it. It was better described by the ENT experts who are the people that should have been testifying about what the duty of Dr. Burgess was, that it was of a consistency of a rotten banana, that it just kind of floated around where it was, and normally these things don't cause people problems.
Mr. Braun,
Yes, sir.
I'm going to go back really quick to that question that Justice Jensen just asked you. And so even if there was, in your view, an undisclosed opinion, I understand that you've provided that or presented that by way of your notice of review. Does that opinion, even if it were credited, in your view, mean that we have the kind of relationship between that continuing care, prescribing the Synthroid, and the underlying allegations? I'm trying to understand where the parties are at on that two-part test from Pitt Hart.
Right. And you asked about the last.
So that second prong requires that relationship, right?
Yes.
So even if this is an undisclosed opinion, even if it's even if it's credited, separate and apart from that issue, what's the relationship in your view of the medical evidence? What's the relationship between that kind of care, represcribing Synthroid, and the allegations of negligence not telling Ms. FRYE-BYINGTON she had this mass? Or is there one, or what does the evidence say?
Actually, there is none. One of the things that the family doctor from Minnesota testified to is negligence of several other people. She testified that the pulmonologist that Dr. Burgess sent Ms. Byington to, well, he was negligent. He should have disclosed. He's not even an agent of Rapid City Medical Center. He's independent of. Then she was sent to an allergist to try to figure out what her problems were. The allergist was not an agent of Rapid City Medical Center. They were going through the same materials, and more importantly, in 2010, Ms. Byington referred herself to the Mayo Clinic. She went to the Mayo Clinic, and she saw an ENT and a pulmonologist, the appropriate experts, to try to decide what her problems were. She took with her the images that were done and read at the Rapid City Medical Center by Dr. Burgess. They didn't see her together. The ENT saw her first. The pulmonologist saw her the next day. Both of them reviewed the images. The ENT felt that she had GERD and offered her surgery, which she declined. The pulmonologist decided she had postnasal drip and prescribed some nasal sprays for her. Both of them read the CT scans, about which they're now complaining, done in 2008, as normal. I mean, that had to break the chain of, we understand what plaintiff is trying to do, and that's create some kind of a chain so they can argue a continuous tort, because that's the only way they can get to this thing. But there are multiple people involved, multiple evaluations done, multiple conclusions that even though they're looking at the same films, they're not seeing anything detrimental to her, and they failed to have the appropriate expert. They didn't have an ENT that said, this is what this means. Only this is here.
Does your repose argument go to Welch and Rafferty as well?
Actually, theirs is quite different, Your Honor. We get down to 2014, and there's a time when she does go to the Mayo Clinic, and she's offered a surgery. She accepts it. They crack her chest and take out this aberrant tissue. Before that, within about 2 weeks before that, first she sees Rafferty, And Dr. Rafferty sees her because she's got chest pain. She's afraid she has a heart problem. He does quite a workup of her, runs tests, gets labs, does this, does that, and then says, okay, I don't see anything. If you're not better, come back in 2 weeks. And in about that period of time, she first of all called in, and she was in a panic. She had seen a naturopathic doctor who had told her that he felt she had a heart problem by feeling her feet. And she said, I need to see a cardiologist. They tried to arrange it. There is no cardiologist, by the way, at Rapid City Medical Center. And then she came in and saw Dr. Welsh. Dr. Welsh did tell her that he felt that somebody feeling her feet and diagnosing a heart problem was BS, because she asked him what he thought of that. But he also said you need to let the experts tell you what is or is not wrong with you, because he was not finding issues that told him that she had a heart problem. He said, we need to get you to a cardiologist. She made an appointment with a local cardiologist to be seen, but she also had, as we already discussed, had been to the Mayo Clinic. She called them. They had an opening for the next week, and she went to the Mayo Clinic. First, she saw a cardiologist. Cardiologist did an x-ray. X-ray suggested some kind of a growth in her chest. CT was done. Cardiologist said, I don't think we've got a heart problem here. I'm going to send you to someone else. So she brought in a cardiothoracic surgeon. The cardiothoracic surgeon concluded that this growth may have something to do with her symptoms of feeling chest pain, offered her the surgery. The surgery was done. At the time of trial, the growth was regrowing. It's hard to say whether the surgery actually solved her problems. We can tell you that through the time of the trial, she had physical problems that made it difficult for her to stay in her seat while we were trying the case. I want to talk real briefly, if I can, about the rebuttal witnesses and V and V1, or V1 and V2.
Question.
Certainly,
Raised several issues on your notice of review.
we did.
If the court were to find no merit in the appellant's issues, what, if any, of those notice of review would need to be addressed in this case?
To make sure I understand, Justice Meyer-Henry, you're saying that if you find no merit in the appellant's two issues, do you have to go to the notice of review? No. And there are two classes of the notice of review issues there. Two of them go to the merits of the case. The balance of them really only go to, if this court somehow finds that we have to retry this case, that there were errors committed, including the undisclosed expert testimony and some other things that need to be addressed then. So I would say this is a three-tier approach that we took to this appeal. Number one, this case never should have been tried. The summary judgment should have been granted on statute of limitations and failure, or statute of repose and failure to have an appropriate expert. And then number two, that Mr. Torno and his client received a fair trial, and there was no error that affected their ability. The jury came to the correct conclusion under the evidence and determined that there was no negligence in this case.
Is there a difference in your view, as a follow-up to Justice Meyer-Henry's question, is there a difference in your view to affirming the jury's determination on the merits, if you will, versus finding that the statute of repose bars an action at the outset? I realize, as a bottom line matter, in either scenario, your client would prevail. But in terms of our disposition, do you see a difference? In other words, on one hand, if we were to hold that the jury verdict was fine, efficacious, we could affirm. That affirmance would be on the merits. Is there a difference for those, rather, the first tier of issues that you talked about,
Yes.
relating to the statute of repose?
I think there is a difference, Your Honor. I mean, obviously, my clients would much prefer to see the public record read that a unanimous jury after a 6-day trial found that there was no liability on the part of any of them, rather than just the time ran. But on the other hand,
Well, some of
both
them
of them
are Class 1. I'm just trying to figure out if there's a difference in your view.
in my estimation, they appealed on 2 issues. And my thought is the court's duty is to first of all deal with their issues. And that would mean that this case would either be affirmed or go on to the other issues for possible reversal, based on the merits. I mean, that's the logical way that it proceeds with me, but I've never sat in your chairs. So, all right. V and V1. Mr. Torno indicated that he felt that those were important and that he was deprived of rebuttal evidence. V and V1 were 2 documents that appeared at 2 separate depositions. He stuck one of them under the nose of Dr. Burgess at his deposition. He stuck the other one under the nose of our expert, ENT, who came and testified that there was no negligence in this case. We were suspicious of those documents to begin with. We gather original records. We try to make sure that our communications with healthcare facilities are that we want everything that's there. We get it, put it in appropriate chronological order, and then it's immediately bait stamped and distributed so that all the council have the same set of documents to work with. Neither V or V1 had bait stamps on them, and it caused us concern. Where did these come from? We raised the issue with the trial court. At the pre-trial, we indicated that we're not stipulating the foundation of those 2 pieces of paper. We'll stipulate to everything else that's going to be used, many hundreds of pages of documents, but we don't know where these came from. They're going to need to lay a foundation. At trial, he did nothing more to lay a foundation for those documents or where they came from or why they aren't in the official records. And then we got to trial. He got Dr. Burgess on the stand and puts those on the table. We objected on foundation. The judge let counsel interrogate him as comparisons to the official record and that one, and over our continuous objection that there was no foundation to put in the substance of these documents in front of the jury until foundation was laid. Ultimately, after the court exhibited extreme patience in this examination, he held that there had not been foundation laid and they were not coming in. Mr. Torno is now suggesting to this court that he could call 2 radiologists whose signatures were on the purported documents and on the official record, frankly, and that somehow he was going to rebut Dr. Burgess' testimony that he had never seen these 2 documents. And he has 3 problems with that. I mean, first of all, we were supposed to finish this trial in 5 days. Friday came, and it was clear we weren't going to finish. The judge started to set it for Monday. I had an unavoidable conflict on Monday, so we're going to finish the trial on Tuesday. On Monday, Mr. Torno had these 2 radiologists served with subpoenas. But he had whoever served the subpoenas took them to the Office of Radiology Associates where these 2 doctors worked and left them with the secretary. Obviously not a proper service of subpoenas. On the morning of the last day of trial, Jeff Hurd showed up representing the 2 doctors from the Radiology Associates, provided 2 documents to the court indicating that his clients were not properly served. They were giving notice to the court that they were not coming. They were not asking for the subpoenas to be quashed because they hadn't been served. As far as we know, nothing else was done with an attempted service of those people, so there were no rebuttal witnesses, so there could be no harm. Second is the things that we just talked about, and that is where did these documents come from? What makes us believe that...
2 minutes, counsel.
Thank you, Your Honor. What makes us believe that without something more, that these two documents were all of a sudden going to come in, that these two doctors were going to know how electronic medical records are transmitted and how things end up on them or whatever. And then the third point is he claims that he was going to impeach Dr. Burgess on he hadn't seen these documents. I mean, whether that foundation could have been laid for him, which didn't happen, or not, neither of these doctors was going to be able to impeach Dr. Burgess' statement that these two documents were never seen by him. In considering the entire matter, on behalf of Dr. Burgess and Dr. Welsh and Dr. Rafferty, we ask this court to find that there is no merit to either of the issues raised by Mr. Torno, that the agency instructions that were given actually gave them a leg up from where they were before, and to note in the complaint that the complaint sues each of those three doctors and all three were served. And then if you go to paragraph 13 of the complaint, it says, I'll pull it out. And I moved. By reason of the relationship between defendant Rapid City Medical Center, LLP, and defendant doctors named, and that was the three that we've talked about, and alleged herein, the Rapid City Medical Center, LLP, is liable for the acts and false and fraudulent representations and omissions of the defendant doctors. Plaintiff has been damaged in the sum of $7 million. The claim that the plaintiffs made in this case was against three doctors and the facility that they were agents of.
And your time has expired, counsel. Thank you.
Oh, thank you, Your Honor.
Mr. Turno, you have 10 minutes for rebuttal, sir.
Laura, I'm going to follow up on on this, the witnesses. First of all, you have to show that there was an abuse of discretion, that the trial court abused its discretion in not allowing you to call them as rebuttal witnesses. And then I think the most interesting thing, what prejudice, how can you show prejudice because of that if it was error?
Thank you for the question. And we would submit that that the trial court here did abuse its discretion in that at first we wanted to lay the foundation. And let's be clear about Exhibits V and V1, and counsel can say, we have no idea where these came from. They had the exhibits. They were provided. And they say, if you look at, I want to say it's Appendix E, the exhibits themselves, V and V1, pretty clear it says Rapid City Regional Hospital, part of RCMC, patient copy. So these are the patient copy. I can't, through my own, through Jody FRYE-BYINGTON, say, did you create this document? She didn't. What we wanted to do is lay the foundation that everything matches. I've never had, in my 33 years, I've never had a document that matches up 99.9%, but is not allowed, we aren't allowed to finish the foundation through Dr. Burgess. And the issue is not...
Mr. Torno, I'm sorry, I have to stop you there a minute. Why couldn't you have tried to tie up the foundation at a point other than rebuttal? How is this rebuttal evidence?
Because Dr. Burgess, especially as to V, indicated he'd never seen it. It wasn't part of the records, and it was.
But he indicated that while he testified.
He indicated that as a part of the defense's case, not at his deposition, wasn't addressed, and I don't want to interrupt if you have more.
Well, so your attempt was to use these to impeach him? To impeach his testimony that he had not seen.
To refute his testimony that he had not seen. That isn't the primary crux, that he hadn't been copied. They weren't part of the Rapid City Medical Center records. They were. And and they want to point to the documents. When you look at V and V1, you'll see the one that they have that, of course, somehow excludes the CC to Dr. Burgess. Those records have been altered. And I'm not casting any aspersions on his clients. What I'm saying is, if you look at the documents, it says archived. So at whatever point they were archived, I believe in 2013, somehow those documents, either they scan down or change them to whatever extent, they have to, because it's added. Obviously, it's not part of the original record that they were archived 3 years and 2 and 3 years later.
But at the time you asked the court to call these witnesses, your opposing counsel has pointed out you had several things that were at issue with your proffer. First, you had witnesses that had not been properly served, with a lawyer indicating such before the court. No affidavits from anyone that they could actually render the testimony that you wish to elicit from them. So if I'm the trial judge trying to determine whether I'm going to allow you to do that, don't you have that obligation in your proffer to make it clear that what you want to offer is actually going to produce what you were trying to produce?
And of course, we did make an offer of proof. We didn't file an affidavit. As to the service issue, they were never, the subpoenas weren't quashed. The trial went 6 days. I know they throw that in as an argument that there was an objection to the service. We could have gotten them served. The point is, and why it didn't go further, is the judge said, I'm not going to allow it. At that point, I wasn't going to go chase my tail around to try to reserve them when he already said, I'm not going to let them testify. And he'd already cut off.
What if the judge had said, what if the judge had said, I agree with you, I'm going to allow them. But we're already 1 day, 2 days late. We're on Tuesday. You can do it, but you got to do it like right now.
Would have done it. Just as Mr. Braun had postponed the trial a day, if we had to postpone it another day, we were kind of on a fluid schedule. It went over time. We would have gotten...
That presumes the court would have indulged that additional delay.
Fair enough.
I still want to know what difference that would have made to the jury's verdict.
Thank you. And I'm glad to get back to that. When we talk about the linchpin of the case, that Dr. Burgess started this process and then through Rapid City Medical Center, and by the way, I would point to paragraph 12 within the complaint as well that says any and all of them, including Rapid City Medical Center, caused the negligent actions. But the harm is that all along they said at trial, Justice, they said Dr. Burgess wasn't their primary care provider. He didn't see any of this stuff. He didn't know anything. These documents specifically say family care provider, Dr. Burgess. That could have been an error, but it shows that within the Rapid City Medical Center community in Rapid City, that's what they considered as the provider. And secondly, that he CC'd on these documents. They're part of the Rapid City Medical Center records all along, and this addresses Rafferty and Welsh too. Counsel sort of laughs as to their involvement. What he didn't tell you is, what came out of trials, they didn't look at the records. They saw her over and over within the statute of repose, the 2-year time period. They saw her, they just kept giving her Z-Packs, but they admitted they didn't look at the records, especially Dr. Welsh. Said he had access to these records, could have seen that the mass was growing, didn't look at them. In fact, Dr. Welsh kind of laughed at that too. Yeah, I had access to it, I didn't look at it.
Mr. Trono, I want to interrupt you. I haven't heard you talk about the jury instruction issue. Tell me specifically, what was the error in the agency instruction and why was it prejudicial?
Thank you. The error was that we presented 30, the standard instruction is modified, 30-50-110. It's a correct statement of the law, and they took out, after going much back and forth, and by the way, it was objected to, they took out the parts that dealt with the other employees and the negligence of the other employees through Rapid City Medical Center. What I was alluding to before is...
Did you have any expert opinions on negligence of other employees other than the doctors?
Yeah, we did, and that's Dr. Wright. And if you look at her opinions, you'll see that she lists out those persons within the Rapid City Medical Center, and I know he likes to point out well, she went to the Mayo Clinic and I believe Rosario. They're outside the circle, but what he doesn't tell you is, but those are also copied or sent there by Rapid City Medical Center and copied to them and a part of their records as well.
But wouldn't the court's instruction, Rapid City Medical Center LLP is liable to third persons like plaintiff for the negligence of its employees? And then it states that rule of agency. So the instruction doesn't say or limit the agency theory to the named doctors or the named defendants. And this obviously was an item of contention among the parties that I read all about. But it says the negligence of its employees. It doesn't really seem to confine it to doctors Burgess, Welch, and Rafferty.
Well, but it does when...
2 minutes, counsel.
Thank you. But it does when you look at both instruction 22 and instruction 23. And what I've been trying to get to, and just want to make this point clear, they say we objected to instruction 23, but yet we didn't propose that objection to the trial court. We didn't object to 23, but when you take 22 and 23 together, the whole of the instructions, they're prejudicial because it says in 23 that the only agents are these 3 doctors. And remember, the trial court allowed us to get into part of the other, those folks under the umbrella of Rapid City Medical Center and insofar as Gillen, but not the others. So I want to make sure I answer Justice's question here. How are we prejudiced? That the jurors ultimately could see through exhibits V and V1 that were disallowed, but again, were verified to every extent that there was notification of Dr. Burgess ongoing after 2009, into 2010, into 2011, and then specifically Rafferty and Welsh, again, those same records, they just didn't review them. And in fact, Rafferty, testimony came out at trial that Rafferty saw my client in Shields later and said, I'm so sorry I didn't read the records. I'm sorry that you're going to have this surgery. He said in his deposition, I don't recall that. He said at trial, I didn't say it. Those are different. But evidence from Jody FRYE-BYINGTON is that he actually, with tears in his eyes, I'm sorry I didn't read the records. That's the tie-in.
The jury heard all that and rendered their verdict nonetheless.
Right, but I correct, and we just think the jury, having heard the critical information within V and V1 that Burgess did know, specifically refutes his testimony. And
had he denied ever seeing those records in his depositions?
V,
Dr.
he
Burgess.
wasn't addressed. V1, I'm trying to remember if he denied. He said he didn't have it. I'm sorry, I didn't re-review the deposition.
Well, I go back to, if those were so critical to your case, why were you not prepared with a witness that could lay foundation to get those documents admitted in presenting your case in chief?
May I answer?
Go ahead.
Because we could do that through Burgess in laying the foundation. We got part of the way through, even to identify the verified ID of the exhibits were identical as to V and V1 to the archived or the changed exhibits that they had. We thought that foundation is appropriate and sufficient, but when we were denied that, then we wanted to refute his testimony.
Okay, thank you.
Thank you.
As a matter of fairness, the jury instruction issue did not come up by either counsel during their direct presentation and did come up during the rebuttal, so I'll allow Mr. Braun 2 minutes to address that issue, if you wish.
Your Honor, you've all seen the set of instructions that were given now to the jury. At Appendix F3, Mr. Torno provided you with what changes that he wanted to make. Our objection to his changes to what is a pattern instruction that's been used the decades that I've been trying these kinds of cases is as it's stated in instructions 22 and 23. Although we made it easier for the plaintiff in this case, because we stipulated that Drs. Burgess, Welch, and Rafferty were in fact agents of Rapid City Medical Center, and that if any of them were negligent, that Rapid City Medical Center was also negligent. We didn't force them to prove that agency issue. What they wanted was an addition that said, including wrongful acts committed by each agent or employee in as part of the conduct of such business employment for the agent employee's willful omissions to fulfill the obligations of the principal's employers. I mean, they were asking the court to put in the court's words what precisely they were trying to prove were negligent acts by the agents. And the jury had already been told that they had to, number one, depend on expert testimony, and number two, the expert had to be of a like specialist of the defendant that they were claiming negligence against. And this...
Is that even negligence? Willful omission may sound like more of an intentional thing.
Yeah. You would think it would be not, but there certainly was not a prayer for any intentional misconduct, Justice.
Actually, paragraph 13, the one that you cited earlier, does talk about some willful conduct.
Yes.
Okay. Thank you, Mr. Braun.
Thank you, Your Honor.
The court will be in recess until tomorrow morning at 9 a.m.